There are two different ways to transfer a lease, and this video will walk you through both of them. There's sublease and assignment. First, let's look at an assignment. An assignment is a transfer of the tenant's entire interest in the leasehold estate. So here we have a landlord, LL, and a tenant who sign a lease. And as signing the lease, the landlord carves out a portion of his or her interest in the property and transfers it to the tenant. The right to use the property for a period of time under certain circumstances for certain purposes in exchange for payment of rent and other covenants in the lease, like duty to keep the property in good repair. So the landlord delivers possession at the beginning of the lease and the tenant moves in. Ordinary situation. This fact of the landlord carving out a leasehold interest and conveying it to the tenant creates privity of estate between the landlord and the tenant. As I'm representing it graphically here, privity of estate is where the interests drawn on the Venn diagram touch each other. Privity of estate is created by possession of the leasehold interest. There's also privity of contract between the landlord and the tenant, and that is manifest in the lease itself, the written agreement that is both a conveyance and a contract between the landlord and the tenant. Here in the subsequent drawing, we have an assignment. The tenant has transferred their entire interest to the new tenant, to T1. The original tenant has retained nothing of the lease. No time of the lease, no control over the property. That is an assignment. After the assignment, the new tenant, T1, is in privity of estate with the landlord, because you can see on this Venn diagram, their interests touch. And the original tenant is no longer in privity of estate with the landlord. However, the assignment does not affect the privity of contract between the landlord and the original tenant. The lease that the landlord and the tenant signed in the original lease creates a contractual relationship that continues to exist after the assignment. So the landlord is now in privity of estate with T1 and privity of contract with the original tenant. Now, presumably, the original tenant and the new tenant also have a contract and are thus in privity of contract with each other. In this circumstance, if T1 defaults on the rent, the landlord has a remedy against T1 because of the privity of estate, but also has a remedy against the original tenant because of the privity of contract embodied in the original lease. If the landlord pursues the original tenant and the original tenant is liable under the original lease for payments, the original tenant in turn will have a cause of action against T1. By contrast, a sublease transfers less than the tenant's full interest in the leasehold estate. So here we start out the same. We have a landlord and a tenant that are in privity of estate and privity of contract. But instead of conveying her entire leasehold estate to T1, here T carves out a smaller interest and conveys that instead. For all intents and purposes, T has created a new landlord-tenant relationship between herself and T1, rather than disrupting the original landlord-tenant relationship that T created with the landlord. T1 is in privity of contract and privity of estate only with T and has no legal relationship with the landlord. Because in a sublease, T has retained part of her interest in the property, T remains in both privity of estate and privity of contract with the landlord. T has obligations to pay the rent to the landlord, and the landlord in a sublease has no remedy against the sublessor. So let's just take a look for a second about what privity of estate and privity of contract are, because it's important to understand these two different kinds of privity. Privity of estate is a property-based relationship, and it arises between parties because their estates are considered one estate at law. So it's limited to situations where there are mutual or successive relations to the same property. We saw this in the context of adverse possession, where one adverse possessor became the successor in interest to a prior adverse possessor. Right? That was a successive privity of estate. There was a transfer of the estate from one holder to another holder. Here we have privity of estate between a landlord and a tenant because they have mutual estates in the property at the same time. The landlord has the fee simple in the property. They own the property. They have carved a leasehold estate out of their fee simple and conveyed that to the tenant. So at the same period of time, the tenant has a leasehold estate and the landlord has the fee simple, but has conveyed the right to use the property to the tenant via the leasehold estate. That's privity of estate. Privity of contract is you're more familiar with, a contractual relationship between parties. It arises when you make a contract. A big difference is that contracts only confer rights and duties on the parties to the contract itself, whereas privity of estate, the rights and duties will transfer with the transfer of the estate. So how do we know which is which? Conveniently enough, many leases routinely use all the words. They'll say, X hereby transfers subleases and assigns. So you got to figure out which one is it. And you'll see in a minute why it matters. Because a sublease, right, does not create any privity of estate between the landlord and the new tenant. And that has ramifications for obligations that the landlord has to the tenant and the tenant has to the landlord. When a tenant who is looking to transfer all or part of their leasehold uses the phrase, hereby transfers subleases and assigns, we have to figure out which one it is. What have they done in this transfer? Have they subleased or have they assigned? And there are two basic ways to resolve this question: a property way and a contract way. So the property way is, if we view the lease as a conveyance of an interest in land, we look at what was conveyed. Did the tenant convey away their entire estate? If so, that's an assignment. Or did the tenant retain a reversion in the leasehold estate, a reversionary interest? If so, that's a sublease. Okay, and that's a nice clean rule, right? Did the tenant convey away their entire estate, or did they retain some reversionary interest? We also can look at, if we treat the lease as a contract, right, that brings in contract ideas about looking at the intent of the parties. So when the language is ambiguous because the agreement says the tenant hereby subleases and assigns, these are two different analytical tools we can use to figure out whether it was a sublease or an assignment. Okay, so let's look at the consequences of subleasing and assigning. Here's a problem. The landlord leases to the tenant for a term of 3 years at a monthly rent of $1,000. 1 year into this 3-year lease, the tenant subleases, transfers, and assigns, that ambiguous language, to T1 for a period of 1 year. And thereafter, neither the tenant nor the new tenant pays rent. So the question is, against whom does the landlord have a remedy for lack of rent? And the options that you have here are against the tenant, the original tenant, but not the new tenant. And the rationale for that would be that T1 has neither privity of estate nor privity of contract with the landlord, or against both of them because the landlord has privity of contract with the old tenant and privity of estate with the new tenant. So basically, to answer this question, what you have to decide is this a sublease or an assignment? And remember, the two tools that we have are look at it as a conveyance and see what the tenant conveyed to the new tenant and use that to determine whether it was a transfer of the tenant's entire interest to a new tenant Or was the tenant carving out a smaller piece of the leasehold and transferring that? If so, it's a sublease. If, on the other hand, the tenant has conveyed everything that the tenant holds in that leasehold estate, that is an assignment. So here in this question, we see that there's a 3-year lease, and 1 year into that lease, T transfers 1 year to T1. So that tells us that year 2 of this 3-year lease is being transferred to the new tenant. That means there's still the 3rd year that the tenant has retained. That makes this a sublease. Because it's a sublease, the correct answer here is 1, that the landlord has neither privity of estate nor privity of contract with the new tenant, and therefore the remedy is against the original tenant. So let's look at that in a graphic representation. Here we have the landlord and the tenant, right, enter a lease, and the landlord delivers possession to the tenant. That creates privity of contract and privity of estate. The tenant transfers an interest to a new tenant, creating privity of estate and privity of contract between the tenant and the new tenant. The question that that problem poses is, what is the relationship between the landlord and this new tenant? And the answer, because in this particular problem, the tenant conveyed 1 year of a 3-year lease, that creates a sublease, and that means there's no privity between the landlord and the new tenant. That lack of privity, there's no privity of contract, there's no privity of estate. That means that the landlord does not have a cause of action against the new tenant. The cause of action remains against the original tenant. Now, there's some ways around that. Same problem, same facts as before, except that in the deal between the original tenant and the new tenant, remember that deal is for transferring 1 year of a 3-year lease. If that written deal, the contract part of that deal, includes a commitment where the new tenant, T1, agrees as part of their deal with the old tenant to pay the rents reserved in the head lease. And what that means, that's just fancy language for the rent in the original agreement between the landlord and the old tenant. If T1 agrees to assume that obligation, now the landlord can argue that this deal between T and T1, even though it's a sublease, is at least in part for the benefit of the landlord to make sure that the rent is paid to the landlord. So let's look at how this changes the relationship. So the landlord and the tenant, again, have an original deal, right? The tenant, again, subleases to a new tenant, creating privity of estate and privity of contract. But because the deal between the tenant and the new tenant includes in the contract a provision that the new tenant will pay the landlord the rent described in the original lease, that means that there's privity of contract between the landlord and the new tenant, sufficient that the landlord can directly sue the new tenant for rent. Now, what happens if instead of a sublease, the tenant assigns their interest in the lease? So here's a problem, right? It's basically the same problem with one difference. The landlord again leases to the tenant for a term of 3 years at a monthly rent of $1,000. And it has the clauses that the tenant covenants to pay the rent on the first of each month, and that the tenant won't sublease or assign without permission of the landlord. 6 months later, with permission, so it doesn't violate the clause that says the tenant won't transfer without permission of the landlord, right? 6 months later, with permission, the tenant transfers all of the remainder of the lease to a new tenant. Okay, that tells us when we see that T transfers the balance of the lease to T1, that is an assignment. The tenant is transferring everything they have to the new tenant. The new tenant pays rent for a few months and then defaults, stops paying rent. And the landlord sues the original tenant for the unpaid rent. Question is, can they do that? And you have three options, right? Option number one is that the landlord's remedy is against T1 because this was an assignment. Option number two is that the landlord has a remedy against the original tenant because they remain in privity of estate. And option number three is that the landlord has a remedy against the original tenant because they remain in privity of contract, even though the landlord is now in privity of estate with the new tenant. The correct answer here is 3, and let's look at what this looks like. So we have an original deal between the landlord and the tenant, right? A lease that creates privity of contract, and then the landlord delivers possession at the beginning of the lease term and the tenant takes it. That creates privity of estate. So we have a landlord and a tenant that are in privity of estate and privity of contract, just like we've had all along. The tenant, in this case, assigns their remaining interest in the lease to a new tenant, right? And that's going to create privity of estate and privity of contract. Because, however, the tenant has transferred their entire leasehold estate to the tenant, they are no longer in privity of estate with the landlord because they don't have any possession of the estate anymore. T1 has all of the leasehold estate in their possession, which means that the landlord and the new tenant are now in privity of estate. When T1 fails to pay rent, the landlord has a remedy under contract against the original tenant and under property against the new tenant. And the landlord can, at his or her election, decide to pursue both of them or one or the other. Now, if the landlord pursues the original tenant for the unpaid rent, the original tenant, who is in privity of estate because the original tenant and the new tenant have successive interests in the leasehold, and in privity of contract with the new tenant, the original tenant can then turn around and pursue the new tenant for any obligation that the original tenant has to the landlord. Okay, so let's look at, I want to show you how bizarre this can get. Let's assume that we have the same original deal between the landlord and the tenant, right, with the same covenants. And then the tenant assigns her entire interest to T1, who assumes the obligation in the original lease. So we have the original tenant assigning to the new tenant, and the new tenant in the deal between T and T1 assumes the obligation to pay the landlord by assuming the covenants in the original lease. T1 then assigns his entire interest to T2, and T2 then assigns to T3. So each time we've seen a transfer of the entire interest in the property. T3 defaults on the rent and maybe fails to keep the premises in good repair, and the landlord sues them all, saying, pay me my money and fix my premises like you promised. The question is, against whom can the landlord prevail and why? Now, it may seem a little absurd, but you'd be surprised how often there are these chain transfers of a lease if it's a long lease. So let's look at what happens. We start, as we have every time, with a deal between a landlord and a tenant. There's a lease, a written lease that creates privity of contract, and the landlord delivers possession to the tenant, and that creates privity of estate. The tenant transfers their entire interest to the new tenant. That means that the landlord and the original tenant are no longer in privity of estate because the tenant has assigned all of their interest to the new tenant. the language of the relationship, the language of the contract between the tenant and between the original tenant and tenant one, right? The assumption of obligations in that contract means that the landlord can make an argument that they can sue the tenant number one directly because they are a third-party beneficiary to this contract between the original tenant and the new tenant. Now, remember, in our fact situation, T1 has also transferred to T2. So we can't say that, right, at the time of this lawsuit, T1 is no longer in privity of estate with the landlord because they no longer have any estate. They have transferred their full estate away. And T2, in fact, has done the same thing with T3. So at the time this lawsuit occurs, you have T3 in possession, not paying rent. And right, there's privity of estate between the landlord and T3 because T3 is in actual possession of the property. So the landlord is still in privity of contract with the original tenant and has a third-party beneficiary claim against tenant one, T1, because of the term that was included in the contract between the original tenant and T1. Notice here, the landlord has arrows going to the original tenant based on privity of contract, to T1 with an argument as a third-party beneficiary of the lease between the tenant and T1, and has privity of estate with T3 because T3 is the tenant in possession at the time that the default occurs. T2, on the other hand, has no relationship with this landlord anymore and cannot be sued. There's no privity of estate and there's no privity of contract because there's nothing in the assignment between tenant one and tenant two that says, I hereby assume the duties in the prior lease. Okay, so this is the kind of puzzle that it's important to work out to figure out who owes what duty to whom in a series like this of assignments. Now, what if instead of the tenants transferring their leasehold estate, what if the landlord sells to a new owner? Right? Remember, the landlord has the fee simple, and they can alienate the fee simple just like the tenant can alienate the leasehold estate. So the landlord sells to a new landlord, right, the landlord's successor, and that will be a written deal because the statute of frauds requires it. So there will be privity of estate between the landlord and the successor landlord. And because the successor landlord is now the possessor of the fee simple, there's privity of estate between the successor landlord and the tenant. There's still privity of contract between the tenant and the original landlord unless and until the landlord and the tenant end that contractual relationship. Okay, so think about if you are the tenant in this situation, what additional agreements might you want? And if you're the original landlord, what additional agreements might you want? And if you're the tenant, you might want a written agreement that indicates that paying the new landlord the rent satisfies this lease obligation. Or you might want this lease obligation entirely eliminated in favor of a new lease between the new landlord and the new tenant, so that the tenant is protected against claims from both landlords, right? And if you're the original landlord, you might want to make sure that this agreement between the landlord and the new landlord guarantees and requires this new landlord to step into the obligations that the landlord has assumed vis-a-vis the tenant. Okay, so I know that's a little complicated. You might have to think through it once or twice, but in the modern world where these interests change hands a lot, you have to think about where obligations exist in an assignment and in a sublease. And if there are successive transfers of interest, who has legal duties to whom? Okay, you got to pay attention to that. Now, what we're going to talk about in the next video after this one is what kind of obligations does the landlord have to mitigate damages for a tenant, and when does the landlord have to consent to a sublease or assignment for a residential lease. So I'm going to end here, and I'll see you in the next video.